Welcome to Within the Frame, where we bring the most pressing issues from across the globe into focus. I'm Kim Mok-yeon. As President Yoon Suk Yeol's impeachment trial nears its conclusion, tensions continue to rise over key testimonies and legal battles. The sixth hearing, held on Thursday, brought intense debate over allegations that President Yoon had directly ordered military forces to remove lawmakers from the National Assembly on December 3rd, a claim that seems to be at the center of the impeachment case. With only two more hearings scheduled, the impeachment trial has entered its final stretch. However, uncertainties remain regarding the possibility of additional witness, potential delays, and broader political implications of the proceedings. So to break down the key developments, we invite Lee Hee-eun, Dean and Professor of Law at Handong International Law School. Welcome, Professor.
Thanks for having me on the program.
And also joining us is Cho Hee-kyung, Professor of Law at Konkik University. Great to have you with us again, Professor.
Hello. Thanks for inviting me.
So let's start with Professor Cho. So we are aware that 6 out of the 8 hearings designated by the Constitutional Court have now been completed, and President Yoon Suk Yeol's impeachment trial has now entered its latter phase. How do you assess the progress so far?
Well, I think the court has been conducting the case very efficiently and at the same time giving the defendant full opportunity to present his case, Yoon's team. So in a normal trial, there are two parts. Usually the complainant or the prosecution presents their case first, and then the defendant would present their case. But in this constitutional trial, it's been slightly mixed. So we've had witnesses from both sides giving testimonies in succession, and so the order is not so clear-cut. But I would say that we are at a point where in an ordinary criminal trial, the prosecution essentially has almost finished presenting its case, and it would be resting its case, and it will be the turn of the defendant to then present their case. But we've already heard from a number of witnesses that have been called by the defendant's side as well. And so the progress is certainly very efficient. And so if we keep going at this pace, I would expect a decision, if not by the end of this month, certainly by the beginning of next month.
Right, so the progress is being held as planned. Now, what about Professor Lee? The sixth hearing, which was held yesterday, was conducted from 10 a.m. and it lasted almost all day, unlike previous hearings. Now, this move is interpreted as an effort to expedite the impeachment proceedings, but some critics argue that the Constitutional Court is rushing only the president's case, raising concerns over a hasty review. What are your thoughts on this, Professor?
Right. So the Constitutional Court here is engaged in kind of a balancing act. So on one side, you have the desire for a speedy trial, which, of course, the defendant would want to have. But ironically, in this case, I think President Yoon wants to delay as much as possible. But on the other side as well, you need to have fairness and, due process. And so the idea here is, under the Constitutional Court Act, there's 180 days from the date of the filing of the adjudication, in this case, the filing of the impeachment petition. The court has 180 days to make a final decision on whether or not to remove the president. So here, as you mentioned, the scrutiny that's being given to the Constitutional Court is whether or not it's trying to speed this process too quickly. But I think, as Professor Cho mentioned, the court has done this, I think, rather efficiently, moving this forward because it's such a high priority case, because the political balance of the country lies with the Constitutional Court as to whether or not we're going to have a new election or whether President Yoon will be reinstated. So, the issue here really comes to the question about speedy trial versus due process. And so, just to give you some context, basically in the two other impeachment cases against presidents, President Moon and President Park. In President Moon's case, the decision came after 63 days later, after the impeachment motion was filed with the court. And for President Park, her impeachment basically took 91 days. So right now, as of today, it's been 55 days since the impeachment petition was filed with the court, and so as a result, we're sort of on pace to sort of either match or be a little longer in terms of the time it took to impeach at least the decisions to be made in both of those cases. And so, as I think we will see, the question about hearing more witnesses, whether the court will then go forward with the considerations of other issues involved in the case. But I think we're on track, to have a decision, certainly, as President Yoon mentioned, maybe by at the end of this month or at the beginning of March, but certainly before any time when the two justices have to retire in April. And I think that's certainly a consideration for the court to get this done and wrapped up in a way that so there'll be no paralysis in the government with this impeachment.
Right, of course, there's a lot of things to consider in terms of time. Now, during the 6th hearing yesterday, key witnesses, including former Special Warfare Commander Kwak Jong-un, testified regarding the military deployment during the December 3rd emergency martial law. Professor, what aspects do you think the justices focused on as key points of contention?
Right. I mean, the focus here clearly is what exactly did President Yoon order when he dispatched troops to the National Assembly, right? Because that's the crux. I mean, that's really the gravamen of this petition, is whether he violated the Constitution, and specifically, did he give an order to drag out National Assembly members and to arrest them, which of course would be a blatant violation of the Constitution. And in this case, because the language that's being used, and this is the testimony, right, in terms of what the commander was ordered by the president to either drag out the members and arrest them. And in fact, that was the sort of the basis for which, the petition to impeach the president was, I think, essentially made. And so, the legal question here, of course, is while the president has certainly the authority to declare martial law, in terms of the application of it and how it's done, has to be done in a constitutional manner. And so this testimony, of course, is going to be very, very sensitive. And so when Commander Kwak was, being questioned by the National Assembly members who are prosecuting the case, and by President Yoon's attorneys and President Yoon himself, there was, at least on President Yoon's side, he denies that he ever gave the order to the commander in this case to actually drag people out of the National Assembly building and to essentially arrest them. And so we have a clear difference, obviously, in terms of the factual sort of basis and the facts that have been established. And so at this point, because there's discrepancy between the two sides, the prosecution and the defense here are going to, of course, rely on the credibility of the witnesses, whether you believe President Yoon or you believe the commander in terms of receiving the order from President Yoon as to whether or not he was ordered to actually arrest National Assembly members. And so if that fact is established, I think the justices then will, have a very hard time. Well, not a hard time, but certainly have a relatively easy decision to go forward with the impeachment. But I think this is why the testimony here was so important as to what the president actually did and what his intentions were with respect to the martial law order. And so I think that's where I think that a lot of the attention has been resting on in terms of Commander Kwak's testimony and then President Yoon's response to his testimony.
Right. And for our viewers who are just joining in, this was, like our Professor Lee mentioned, this was one of the most contentious issues, whether President Yoon had ordered to drag out lawmakers from the National Assembly. And there's ongoing row about the subject of whom Yoon ordered to bring out, with Yoon saying it was agents, while Special Warfare Commander Kwak Jong-un, he says he heard it to be a number of people. Now, all of these lawmakers, number of people, it's all quite similar. They have a similar pronunciation in the Korean language. Professor Cho, given this conflicting testimonies about the subject of whom to drag out, what kind of criteria will the Constitutional Court use to establish the facts?
Well, it will be the same rules of evidence as you would apply to any other evidence that the court would examine to see if it actually proves the fact that's being contested. But personally, I actually think this dispute regarding was it lawmaker, i.e. 의원, or agent, or 요원, or number of people in one, it really doesn't matter. It's really a storm in a teacup, as it were, because I would actually direct people who are interested to the exchange between Justice Kim Hyung-do and Commander Park Hyung-gun regarding this very point. So, as Professor Lee explained, the President Yoon's side is claiming that he ordered the commander to drag out agents. But commander says, I heard in one, so number of people, and who was actually within the assembly hall, which is the location that they were supposed to be dragging people out from. There were no agents at the time inside the hall. And agents would simply require just one word from the commander to, vacate the premise, and they will follow. So why would you need to drag them out? Plus the fact that before the word agent or lawmakers, etc., was used, you have to look at the context of what was spoken. And it was clearly said, and this was not contested by the president's side, the quorum has not been reached yet. And so use whatever means necessary, break down doors if you have to, and drag whoever out, whether it be agents, etc. And so in that context, why would you think that agents would have a quorum inside the assembly hall? So the court would look at reliability, credibility, and authenticity of the evidence. And given that this is a testimony and not physical evidence, you also look at whether it's corroborated by other evidence. And Commander Kwak's evidence is being corroborated by his subordinate. And in fact, the exchange between him and the president was actually being heard over loudspeaker, which was still turned on. And so there is so much more corroborating evidence that supports the credibility of what Park is saying, as opposed to Yoon, who has proven to be a very unreliable witness throughout the whole trial.
Right, so the court will have to take into consideration the credibility of the testimonies as well as the actual situation on that day. Now, with only 2 more hearings remaining, President Yoon's legal team has requested that the Constitutional Court hold weekly hearings, emphasizing the need to fully guarantee his right to defense. Professor Cho, what is the likelihood that the court will grant this request?
Well, you have to wonder, why are they requesting a weekly hearing instead of a twice weekly hearing? And they might be arguing that, well, we need more time to prepare, etc. But they've had equal amount of time as the other side. And if anything, they actually have more manpower on their side. And so I think it's quite unlikely that the court would actually accede to their request. And also, just going back to the actual length of the trial and whether the court is rushing the trial and rushing President Yoon's hearing, you also have to look at, as Professor Lee mentioned, it in the context of previous 2 impeachment trials that we've had with regard to President No and President Park, because the issue here in Yoon's case is very simple. We are just dealing with one issue and one issue only, which is whether the martial law declared by Yoon on the night of 3rd of December was an insurrection that basically shows his unwillingness and inability to comply with the Constitution. Whereas Park's case was much more complicated because it involved lots of different corruption allegations, bribery, involvement of private person in state affairs, etc. And so there was a lot more factual issues to be sorted out and sifted through. And so this is much more akin to No's impeachment in terms of the complexity of the issues at hand.
Mm-hmm. Now, the 8th hearing, as we know, is scheduled for the 13th, and it's currently the last designated hearing. But the Constitutional Court has yet to decide on President Yoon's request to summon Lee Kyung-min, Chief of Staff of the Defense Counterintelligence Command, and Prime Minister Han Duck-soo as witnesses. Professor Lee, do you think additional hearings or additional witnesses would be granted?
Well, in this case, just looking at the overall context of President Yoon's request, so you have to remember here that President Yoon's side has asked for, basically 31 or more witnesses to be presented at the Constitutional Court hearing, and the court accepted only 8 of them. And in this case, the request to have, in this case, the Prime Minister testify, as well as one additional person, I think really goes to Lee Hee-eun here is the court didn't make a final decision, and really the court has to sort of, again, as I mentioned before, balance between, again, whether or not to move forward with an expedited or at least efficient trial process, or how complete and how much do you want to give President Yoon the opportunity to present his case, but at the same time understanding that not all of his witnesses that he's requested will have the opportunity to actually hear and to be part of the trial. And so whether or not the Constitutional Court accepts these 2 additional witnesses, that means that there are going to have to be additional hearings, because at the current rate, in terms of what the court has decided, the final hearing is supposed to be on the 13th of February next week. And so if the court decides to accept these 2 additional witnesses, you have to expect that the court will then have to have additional time to hear those witnesses, and then to wrap up essentially the hearings, and then decide at some point to make a final decision. And so it's really hard to say at this point as to whether or not the court will make a decision to accept these 2 witnesses, because the court has reserved judgment on them. But if the court in this case is concerned about the impression that the president has not been given enough opportunity to present his side of the case, then the court will probably accept the 2 witnesses. But if in fact the 2 witnesses that are going to be heard here have really no relevance, or they're not going to their testimony is not going to really add anything to the impeachment trial as to the specific issue of whether or not, again, President was violating the Constitution by then ordering the military to impede the work of the National Assembly, whether or not those 2 have any relevance will, I think, be the essentially deciding factor as to whether or not they should be called. So I think we'll just have to wait and see as to whether or not the court will then decide as to whether or not this will go forward with these 2 witnesses.
Right, so we'll see until the court makes a decision on that. But meanwhile, President Yoon's legal team has filed a motion with the Seoul District Court requesting the cancellation of his detention rather than bail. Professor, what's the reasoning behind requesting for a cancellation instead of a bail? The court must, decide within 7 days. Do you think it would be approved?
Well, there's 2 sides to this. So the court, his lawyers have made 2 basic arguments. One's procedural, and the other is substantive. So on the procedural side of things, essentially, the claim that's being made by President Yoon's legal team is that while he was in detention, the prosecutors should have then indicted him while in the process of his detention. And so if the detention period has lapsed, then the prosecutors don't have the authority to indict him because the period of detention has gone over. So this is actually just a timing question, and it's a question that lawyers deal with regularly as to when you should count the time for when something should be done. And so in this case, when you consider President Yoon being detained is really the question here. What time was he detained? Because within that period of time when the prosecutors can hold the president, they should have made the indictment. So again, the question here really is the beginning of his detention. When was that? Because on the date of the 5th of January, he was arrested at 10:33 a.m. And so basically, the initial arrest period should count until the midnight of the 24th, according to President Yoon's legal team. And so therefore, since he was indicted after that, then it should be an illegal indictment. But the prosecution says no, the detention period is extended for another couple of days because you don't count a certain time when it comes to the arrest. But I think the more important, that's the procedural side. But on the substantive side of things, he's saying basically, his legal team is saying that there's no grounds for holding that there's an insurrection charge, or that should be a validated charge against him under criminal law. And so as a result, because there's no the elements of insurrection have not been met, this indictment is substantively flawed. And so he's really presenting two sides of this argument, on the procedural side and on the substantive side. And that's what the court will have to decide on those bases.
Mm-hmm. Now, let's also touch upon the judges. Previously, the Constitutional Court postponed its ruling on whether acting President Cho Sang-mok's decision to not appoint Ma Eun-hyuk as a constitutional judge was unconstitutional. The ruling is now scheduled for the 10th. And Professor Cho, do you think a final decision would be made this time? And could you also tell us how it would impact the impeachment trial?
So my understanding is that the court has actually accepted the request by acting President Choi Sang-mok to present further his side of the case. And so there is a hearing scheduled for the 10th of February. It's not usual to have a decision on the same day as the hearing. So I'm not entirely sure that a decision will be handed down in that case on the 10th. Now, I think the reason why they decided not to issue the ruling on the 3rd as originally planned, but actually accepted this additional request for presentation of further evidence by Choi's side, is once again to ensure that there is due process, because there was some complaint, I believe, that there was a hearing initially of only an hour and 20 minutes on the 22nd of February, and then the court announced that they would pass down its ruling on the 3rd of February, on the 22nd of January, and then, ruling on the 3rd of February. Now, usually that wouldn't actually raise an eyebrow here in Korea, because most of the trial process actually takes place by paper, i.e. documents, rather than oral hearing. It's very unusual for courts to have this amount of oral hearing. We think that this is kind of normal, and we are accepting this to be the standard because we are seeing this all happening on screen. But in a normal trial, most of 95% of the trial is actually taking place without hearing inside the courtroom. And so that's how the court would have proceeded usually. But this is an extra step that they're going further. And so I doubt that an actual decision would be handed down on the 10th, but they may also, have the hearing in the morning and the decision in the afternoon. It's really up to the court.
Right. And could you also shortly tell us about its impact on the impeachment trial as well?
Oh, yes, certainly. So if they accept that Ma Eun-hyuk's, non-appointment of Ma Eun-hyuk by acting President Choi is unconstitutional, then that would mean that Ma is entitled to be appointed, and they might still wait for Choi to proceed with that formal official act of appointment. But at the same time, the National Assembly side has actually requested an interim order simply to appoint Ma as the justice on the court. And if the Constitutional Court accepts the interim order, then Ma would straightforward, from that moment in time, actually have the status of a Constitutional Court justice. The impact on Yoon's impeachment trial is that this might actually extend the time, because Ma joining the bench means that Yoon would, obviously request for the whole hearing to be essentially informed, for Ma's benefit, which would take more time. And so that could be used as a device to, again, delay the court procedure. However, the Constitutional Court might also actually decide not to include Ma in the process and not actually give the interim order, because the trial process has gone on for so long and so much of it has already been done And so they may not feel that this is appropriate. So a lot of people are arguing that the Constitutional Court really wants to have the full bench, 9 justices deciding on the case. But at the same time, I think there is a big question as to, is it really fair and just to have this one justice joining very late at the process and still participating in the decision? And so my personal thought is that, in Park Geun-hye's impeachment trial, we also had only 8 justices, and they were in full consensus regarding this decision. In this trial as well, I think it's very difficult for there to be a minority decision regarding the actual outcome of the case. So I think it's not strictly necessary that Ma needs to be joining.
Right, so we'll really have to see because the ball is really on the court side. Now, thank you so much for your insights tonight, Professor Cho and Professor Lee. We'll have to wrap up at this time, but we'll hope to talk to you again soon.
My pleasure to be with you.
And that'll be all from us on Within the Frame. Be sure to tune in next time as we continue to explore the stories that matter. Until then, stay informed and engaged.